Mr. REAICH, who will be the first discussant of this panel. The time is yours.
Kia ora koutou e ngā rangatira. Good morning, distinguished guests. Firstly, let me start by thanking our gracious hosts for organising this conference. I must especially thank my friends and colleagues in the International Legal Affairs Bureau of the Ministry of Foreign Affairs for their leadership both in organising this conference but also on law of the sea issues generally, so thank you for hosting us. Please allow me also to thank and acknowledge our extraordinary panel today, particularly our esteemed moderator, Judge INFANTE CAFFI, our two extraordinary speakers, and my fellow discussant. I'm humbled to be part of such an august panel. So, at the outset, it might be useful for me to talk a little about New Zealand's approach to the UN Convention on the Law of the Sea. The starting point for all of us, I'm sure, is that the Convention is and has been for more than 40 years a mainstay of international law. As Vice Minister Kang indicated this morning, the Convention is perhaps the most important multilateral treaty we've seen over the last century, with the exception of the Charter itself. New Zealand remains deeply committed to upholding the Convention's position as the definitive legal framework from which all activities in the oceans and seas must be carried out. And like many other states, we regard the Convention as being the constitution for the oceans. And so as we commemorate the 30th anniversary of the entry into force of the Convention, we see its negotiation as a historic achievement and a shining light for multilateralism. And I'd like to respectfully endorse your comments, Judge Haidar, earlier this morning about the status of the Convention. While the Convention is still young in relative terms, it is difficult to imagine now a world without it. It protects and empowers us, it preserves a balance of rights and responsibilities, about which more in a moment, and it provides the legal framework under which all activities in the ocean and on the seas must be carried out. And so that is also why this conference is so important. It allows us to reinforce our collective understanding of the universal and unified nature of the Convention. And in that way, the conference contributes to the strengthening of international law. I'll conclude by noting I've put my favourite map on the slide there. There are so many maps, including, unfortunately, Professor Davenport, one of yours this morning, that omits New Zealand. So I like to choose one that really only has New Zealand on it and the blue Pacific continent. So the question of sovereignty or jurisdiction in maritime zones is an important and topical one. Perhaps the foundational question is, where do those zones begin? How might those zones change in the future? For New Zealand's part, we're committed to ensuring the preservation of maritime zones in the face of climate change-related sea level rise. Our view, and it's not ours alone, is that states can maintain their maritime zones as notified under the Convention to the Secretary-General, and the rights and entitlements attached to those zones, notwithstanding any physical changes connected to climate change-related sea level rise. This is an important issue for many states, including many Pacific Island countries. The picture on the slide indicates or gives you an idea of the issue. It is a view of one of the atolls of Tokelau, which is a non-self-governing territory of New Zealand in the Pacific. And you can see for the New Zealand citizens living on those atolls, along with many thousands of other Pacific Island citizens, that the question of sea level rise is indeed an existential one, not merely a legal one. So therefore, New Zealand was pleased to play a part, along with the leaders of many other Pacific Island countries, back in 2021, when Pacific Island Forum leaders made a declaration on preserving maritime zones in the face of climate change-related sea level rise. We also very warmly welcomed the meeting on this issue at the General Assembly back in September, and we're pleased that the international community has founded this program of work on an ongoing basis. And of course, we were pleased to participate with so many other countries in the advisory opinion in ICLS. So I turn now to the topic of this session, jurisdiction in the Territorial Sea. Perhaps the obvious point for me to make is that the relative importance of the Territorial Sea and other maritime boundaries depends on your geography. And you can see from the slide that New Zealand has very few issues arising from our territorial sea. Our neighbours are a long way away, and they're friendly, if you include Antarctica as being friendly, but let's say for the sake of argument that it is. So our focus is primarily on our exclusive economic zone and the extended continental shelf. And of course, we're strong supporters of the Agreement on Biodiversity Beyond National Jurisdiction, and we look forward to it entering into force as soon as practicable. And you can see from this slide the importance of maritime zones and boundaries to Pacific Island countries. So maritime boundaries, the rights and responsibilities of maritime zones are extremely relevant and extremely important to the Pacific region. So let me turn to the excellent presentations that we've had this morning, and I'm grateful to our two illustrious speakers and Madam Moderator for their insightful remarks. I approach my remarks from the perspective of someone in the South Pacific and from the perspective of a Foreign Ministry legal advisor. Professor Davenport's presentation brilliantly conceptualises notions of coastal state sovereignty over the territorial sea. The presentation contemplates a reconceptualisation of the territorial sea as a space of shared rights and responsibilities. Perhaps how one approaches that notion of reconceptualisation again depends on one's geography and on one's role. Whether one supports the idea of shared rights and responsibilities depends perhaps on what one has to gain or lose from them. I would say as a Foreign Ministry legal advisor in a Pacific country that does not have near neighbours, I personally am very much on the despotic and absolutist end of that spectrum. We view the territorial sea as being under our sovereignty, subject only to specific limitations agreed to in international law. There are, of course, competing interests in the territorial sea, including freedom of navigation, and Professor Davenport helpfully set out the important jurisprudence of UNCLOS courts and tribunals on possible limits of coastal state sovereignty. Professor PETRIG's outstanding presentation raises important issues about coastal state jurisdiction in the territorial sea, international human rights law, and the application of transnational criminal law. The focus on these issues and how they relate to innocent passage is very welcome. I would add in the case of both of the examples that we heard about, including submarine cables and the application of international human rights law to vessels, foreign flagged vessels in the territorial sea, as being relevant and topical issues. I would add though that as a Foreign Ministry legal advisor, the legal position is only one of the considerations, of course, that a government would be looking at very closely when determining what to do. And we've seen from headlines this morning in respect of the Baltic Sea how timely and important these issues can be. Professor PETRIG notes that there is still uncertainty about a number of these issues, and there's a need for further work and study. We also note the very important work that is being undertaken on some of these issues by the International Maritime Organisation. Like very many other countries, New Zealand has enacted legislation to set out clearly what maritime powers our agencies may exercise in the territorial sea. Our Maritime Powers Law, enacted in 2022, was designed to expressly comply with our international law obligations while at the same time securing our maritime environment against threats such as drug trafficking, wildlife trafficking, and human trafficking. More broadly, and again, just to repeat the record, as a government legal advisor, I would be very cautious about developments outside multilateral processes or outside the processes of international courts and tribunals. The reason, obviously perhaps, for that caution is to avoid in any way diminishing the coherence, status and primacy of the Convention. So if you'll allow me, I'll conclude where I started by saying that the UN Convention on the Law of the Sea reflects a carefully negotiated balance of rights and obligations that serves all of our interests. New Zealand will continue to promote and defend the status of the Convention as the primary international treaty governing ocean activities. So please allow me to conclude by again thanking our gracious hosts and my esteemed fellow panellists. Thank you very much.
Thank you very much, Ambassador REAICH. And now I invite Dr. Kim to conclude with the discussion of this panel.
Thank you, Madam Chair. I'd like to express my sincere gratitude to the organizers, Ministry of Foreign Affairs, International Tribunal for the Law of the Sea, and Korean Society for International Law. It is such an honor and great pleasure for me to be part of this very meaningful gathering for commemorating the 30th anniversary of the entry into force of the United Nations Convention on the Law of the Sea. I'm also really enjoying and learned a lot from two speakers. They spoke about the coastal state jurisdiction of the Territorial Sea, but one speaker, Tara, mentioned that the development of the convention, the UNCLOS, can restrict the coastal state jurisdiction of the Territorial Sea. On the other hand, Professor PETRIG, mentioned, argued that the coastal state jurisdiction and coastal states' power to regulate activities in the Territorial Sea could be transformed into the obligation to protect of the human rights in the Territorial Sea. So I found it very interesting to presentation. So I'd like to ask some question and give some comments. And just for your information, I don't want to be a bad guy to destroy your house of cards, but I will be very faithful to my role as a discussant. Before beginning my discussion, I'd like to quote my favorite writer, Philip C. Jessop. He wrote a book about the law of territorial waters and maritime jurisdiction. It was published in 1927. So I quote, "If sovereignty is an absolute thing, any restriction upon it is its own negation. But such a concept is not in accord with the facts of present international life. International law itself is a restriction upon and a denial of absolute sovereignty. Most treaties, though freely entered into by an exercise of sovereign will, thereafter constitute a limitation upon sovereignty." End of quote. So even in 1927, it's only that Philip C. Jessop mentioned that some possible limitation of the coastal state sovereignty of the power in the Territorial Sea. And our discussion today, I think that our discussion in this session is focusing on the interpretation of Article 2, Paragraph 3 of the Convention. That means the sovereignty of the Territorial Sea of the coastal state is exercised subject to their sovereignty, subject to the Convention and other rules of international law. So both speakers mentioned that what is the other rules of international law. So in my opinion, I think that we should be some cautious to identify which will be the other rules of international law. So my first question goes to Tara. So Tara explained and so gave us some examples of the three cases, the Chagos MPA arbitration and South China Sea arbitration and Dujit integrity arbitration. But it seems to me that the three cases are very fact-intensive cases, and they have very unique factual backgrounds. So, for example, Chagos MPA arbitration, the legal basis of the tribunal to recognize the limitation of the exercise of territorial, the UK's power over the territorial sea was the UK's commitment to return the Chagos Archipelago arising out of the Lancaster House undertakings. So the basic legal ground for the tribunal to render to limit the exercise of the power of the coastal state was not the other rules of international law, but from the UK's commitment. So the South China Sea applies the same. The traditional fishing activities done by the Filipino and Chinese fishermen was the legal ground for the tribunal to render the limitation of the exercise of territorial sea. So my question is whether it is appropriate to draw some limitation. Is it appropriate to draw some generalization to limit the sovereignty over the territorial sea from those cases? Is my first question. And second question to Tara is that is there any existence? Is there any existence of general rules regulating the laying and repairing marine cables in the territorial sea? So there have been developed the 1884 Convention on the International Marine Cables. So there are separate legal regime regulating the submarine cables. So if we argue that the sovereignty over the territorial sea could be limited in the territorial sea, then we should look for any evidence that there exists a general rules of international law to limit the sovereignty over the territorial sea. So the next question goes to the Professor Anna PETRIG. So I really appreciate your meticulous analysis on the relevant rules and external rules relating to protection of the human rights. And I got some impression that there have been many scholars, especially Irini, pointed out that most lacking regulation under the convention was the protection of person at sea. So it's still, I'm sorry that even we are commemorating the 30 years of the entry into force of the convention, we are still suffering the same problems. So I really appreciate Professor Anna PETRIG's attempt to theorize to oblige the coastal state to exercise jurisdiction of the territorial sea to protect the human rights. However, there are some suspicion and there are some doubts over your argumentation. So my first question is about the general rules of treaty interpretation. So you try to interpret Article 25 of the Convention that there exist other rules of international law may control the right of passage. But when we recall the general rules of interpretation of the treaties under the Vienna Convention on the Law of the Treaties, Article 31 and 32, do you think is it consistent with the general rules of treaty interpretation under the Article 31 and 32? Because it seems to me that the only ordinary meaning has no relevance to the protection of the human rights in the convention, and also context and object and purpose of the convention was not envisaged for protection of the person at sea in the territorial sea. So in this case also there are some separate legal regime developed to protect the person at sea, like a Convention on Maritime Labors and other relevant IMO's conventions. So my question is that whether your interpretation of Article 25 is consistent with the general rules of treaty interpretation. My second question is about the terminology of the jurisdiction used in the Convention on the Law of the Sea and used in the international human rights treaties. For example, the Article 1 of the European Convention on the Human Rights, I quote, "The high contracting parties shall secure to everyone within their jurisdiction the rights and freedoms defined in Section 1 of this convention." So the same, almost similar provision was provided in Article 2 of the International Covenant on the Civil and Political Rights. So I quote, "Each state party to the present covenant undertakes to respect and to ensure to all individuals within its territory and subject to its jurisdiction." So it seems to me that the international human rights law imposed the obligation of the state party to protect the human rights of the everyone within their jurisdiction. So that means that article is relevant for the scope of application. It is not relating to the exercise of the coastal state jurisdiction over territorial sea. So whether, I have some question whether there is any confusion of the using the terminology of the jurisdiction of the coastal state over territorial sea and the protection of the people within their jurisdiction under the human rights treaties. And my last question is about the external rules. You mentioned that the ICLS advisory opinion on climate change and international law, it is quite a historical judgment, historical advisory opinion to clarify the meaning of the marine pollution relating to the emission of the CO2 and relating to climate change. But the ICLS has clearly declared that the convention and external rules should be interpreted consistently, and also the external rule should clarify the meaning of the convention. It's not the incorporating the external rules into the convention system, because the UN Convention on the Law of the Sea has adopted a compulsory mechanism of the dispute settlement. So I think this is the most important part of the convention, and many contribution of the peaceful settlement of the maritime dispute. But if we are extending to incorporating external rules like the human rights treaty obligation into the Convention on the Law of the Sea, so is there any possibility to expand, too much expand the scope of the convention? So I totally agree with that. The convention is a living instrument, and openness and generally accepted international rule and regulation could be referred. But we should be careful about that the external rules should have to clarify the meaning of the convention, not to expand the legal obligation under the convention. I have 2 minutes more, but yeah, that's my question. Thank you very much. Thank you.
Thank you very much, Dr. Kim. I think our speakers have had enough questions to answer. And unless you would like to raise another point, I will invite you to address these questions.
Very much for the very useful comments. Just to emphasize one more time, it was a thought experiment, and I guess this analogy of a house of cards fits very well. And it's interesting to see that Tara's presentation and my presentation went in opposite directions. You taking something away from the coastal state, where I rather made an argument on how to expand coastal state jurisdiction. But still, I guess we agreed on several points, such as there is much uncertainty about the extension of jurisdictions of the coastal states. Also, this idea that it's an area of shared rights and obligations, the constant need of balancing, plus what you said, sovereignty comes with responsibility. I guess prima facie we do not quite align, but if we look a little closer, I guess our claim is very different. Then I very much agree that with what Mr. REAICH said, that the position may very much depend on or how you look at things, about your geography and other interests, and there is a political dimension. What I did was a very sterile exercise, a purely legal exercise to test the limits. Of course, then you have to hold that against the background of politics and other interests. And I very much agree that we need a cautious approach, that developments should take place in a multilateral setting. Courts and tribunals should develop the law in this respect, and there are now several interesting developments going on in the area of the protection of people at sea, which could maybe ultimately lead also to a multilateral process. Then I'm very grateful for all the questions posed by Kim. So the general rules of treaty interpretation, I guess we have to distinguish Article 19 from Article 25, because Article 19 has an explicit reference to other rules of international law. So at least some see this as the possibility to really integrate other rules of international law into the innocent passage regime. I do not necessarily agree with this very liberal interpretation. I have mentioned there are two readings of what this means, whether it's just this reference to other rules of international law are just an invitation to consider the rules of the UNCLOS in light of external law, or whether external rules really control the passage regime. And so in Article 19, since there is this explicit reference to other rules of international law, this could go beyond systemic integration. But I guess a more narrow reading prevails if I look at the literature, and there it would just be systemic integration, meaning you consider the rules in light of external law. And then, of course, there is the wording, but the wording is not very helpful. What does good order means, or any activity not bearing on passage? So. But I have also emphasized the context. It's clear that a certain threshold of gravity must be there in order not to disturb the overall balance between coastal state rights and flag state rights. So I very much favor an interpretation which takes into account all types of interpretation rules, but I guess systemic integration is a method of interpretation which is increasingly important. Then yes, the terminology on jurisdiction, that's a very vexing thing, that both in human rights law, in the scope of application provisions, jurisdiction is used, but jurisdiction is also used in general international law and law of the sea, and they do not mean the same. I tried to avoid the notion of jurisdiction in my talk. I referred to relation of duty, and actually, jurisdiction in the human rights clauses mean to whom do you owe an obligation. And you owe to them, to all persons under your jurisdiction, which can mean under your de jure jurisdiction, under international law, or de jure jurisdiction under the law of the sea, or even de facto jurisdiction if you have no entitlement to act, but for instance you arrest someone at sea. So jurisdiction in the sense of human rights clauses can mean jurisdiction de jure and jurisdiction de facto. And so you have three terms which sound similar but which are very different. And my argument is not that human rights jurisdiction should control the jurisdiction at sea, but if you have jurisdiction under the law of the sea, that may determine to whom you owe the human rights obligations, because the scope of application provisions of human rights treaties refer to de jure jurisdiction. So it's linked but different, and it's a very complex problem, and there is an ILA committee which has been recently established which will study just this notion of jurisdiction for the next 4 years, which testifies to the complexity of these notions. Then again, external rules, whether they should just be taken into account or whether they could also expand the obligations under the law of the sea, that again very much depends on how you read this clause. And it could mean just systemic integration, or it could mean more. If you look at all the case law, it's very contradictory, but it seems that recently there is a trend towards a more restrictive understanding that it's just systemic integration. But even then you have somehow to take into account human rights law, and the nature of human rights law and transnational criminal law is very different. It has this obligatory character, so how do you deal with this in a law of the sea regime which is more permissive? And I guess this balance has to be struck in the future, and as mentioned, we are at the very beginning of this development, and my presentation was not at all a lex lata presentation, but really like a thought experiment and an invitation to reflect upon these complex interactions. Thank you very much.
I do apologize as well for losing my voice in the middle of my presentation. I'm sure it did not sound very pleasant. Again, I'm losing my voice. Thank you very much for the very thoughtful comments by Mr. REAICH and Dr. Kim. I think I will again borrow from Anna to say that it was a thought experiment, really trying to interrogate the nature of coastal state sovereignty and the limits to it, which I think in the Law of the Sea Convention, with the exception of the innocent passage rules, there's still considerable uncertainty. And I think also in relation to this idea of competing conceptions of sovereignty, sort of as a normative basis for understanding the limits to coastal state sovereignty, I think I was very interested in this idea of, which is why I emphasize this, the property theories that actually gave rise or, developed into sovereignty theories. So this idea that we have, Blackstone, I teach land law in Singapore, so everything is infused with some sort of property. But this idea that our conception of property is sort of sole and despotic dominion, this idea of complete control, the right to do what we want, in this case, within the territorial sea. And I was interested in, alternative conceptions of sovereignty, and this idea that, which I think the case law has slowly or alluded to without maybe explicitly doing, that there are limits to coastal state sovereignty. I think I completely agree that it really depends. I think most coastal states would very much take the position that the territorial sea is part of their territory. It is their sole and despotic dominion. And I think that's it is a very realist and natural position that coastal states will take. Coming back to what Dr. Kim said, and I think I did not, and his questions actually made me think about what I did not say, which is that there are both substantive restraints on coastal state sovereignty, for example, through the obligation not to harm. You can't use the territorial sea in a way that will harm other states. But I think what both the Chagos Marine Protected Area arbitration and the Dusgit arbitration was alluding to was this idea that, I don't like to call it procedural obligations, but the way that coastal states exercise their jurisdiction are subject to certain restraints, whether it be good faith, whether it be proportionality, right? That it has to be something that is exercised in a proportional manner that, protects your interest in sovereignty, but does not excessively impact other states' rights. So I think these are the, and he's absolutely right to say that you can't draw sort of, general conclusions because they are very fact intensive. But I think what these arbitral cases, I guess, are building towards is that there are limits on coastal state sovereignty, at least in the way that they exercise their jurisdiction. There are no existing rules under rules of international law in relation to submarine cables and pipelines. But I think what I was very interested in is this idea that in the EEZ and in the high seas, freedom of navigation has been recognized, freedom to lay submarine cables and pipelines. Both of these are sort of part of the general idea of freedom of transit, freedom of communications. Navigational rights were protected in the territorial sea, but there was no equivalent protection given to the right to lay submarine cables, even though they're also essential to this idea, a general idea of freedom of communications and so forth. So I think that was something I was very interested to explore further. Again, it was a thought experiment. I think it would be very hard to argue or to challenge this idea that the coastal state can do what it likes within its territorial sea and can regulate. But I think it is an interesting way to sort of interrogate the nature of coastal state sovereignty, and maybe we also need to reconceptualize it as I had said earlier, this idea of shared rights and responsibilities.
Thank you very much. I would like to conclude we're going to conclude this panel with a very thoughtful, yes, and heartfelt thank you to all of you. You have provided insights in order to counter these uncertainties. I think there are more certainties than uncertainties in what you said, and thank you very much for your presentations and discussions.
Thank you. Once again, please. Thank you very much, Judge Infante CAFFI, and also my gratitude to all of our panelists for the discussion. So please, once again, applaud for our moderator and our panelists, please.